who's telling me that he is from the Métis community of Detroit. And not like contemporary Detroit, Detroit from the 1700s. And that's how he claims his Métis status. So I said, well, where are your cousins? Where's your aunties and uncles? Blah, 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 blah. How dare you, because of the ravages of colonialism, yada, 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 yada. Oh, I thought you were waving. Hey, Shani. So, anyway, in the end, the book, in the conclusion of the book basically attempts to talk about what are some or at least less racialized ways that we can talk about Métis identity and the Métis people, and it suggests a couple of different kind of conceptual apparatuses. That's basically the book in a nutshell. It's the second book I wrote. I ended up writing 2 books last year after 12 years or 13 years of writing no books whatsoever. So the sabbatical came at just the right time. The other book is on Indigenous statistics, in case anyone's interested in that. And it's called, cleverly enough, Indigenous Statistics. So you can look that up if you. So anyways, thank you very much, and thanks, Shani, for inviting us.
I'd like to open up the floor to folks that are here with us today to see if they have some questions or they have comments that they'd like to make. So I invite your conversation.
But ask a question.
David,
Exactly.
Chris, I wondered if you could elaborate on the status of the Sault Ste. Marie Métis. That argument in the book.
Yeah, I mean, to me, the Sault Ste. Marie Métis are Métis, but they're not Métis for the reasons that the Paulis, that the Pauli decision seems to think that they're Métis. Okay, the Pauli case was basically, it's an age-old story, really. Father and son go hunting, father and son bag a moose, father and son bring the moose home, somebody calls Crime Stoppers on them, they come in, they charge them with hunting out of season, hunting without a license, confiscate everything, yada, yada, yada. So they go to court, they make an argument that because First Nations, under the Robertson Superior Treaty, don't need a license to hunt, they shouldn't either, because they're Métis. And because they're Métis, they have particular land-based rights in the area. So what the court eventually decided was that in order, how do I put this? People often say that the court defined what a Métis is. The court didn't define what a Métis is. They were very specific to say these are the legally defensible and legally protectable elements of Métis, and this is what you have to be able to demonstrate in order to seek protection for that. So self-identification, attachment to a community, a contemporary community, and attachment to a historical community. And they didn't necessarily say blood quantum attachment or a lineal attachment. People could have been adopted into a particular community, but you had to show attachment to some pre-colonial, what they call pre-effective sovereignty community. The problem with the Pauli decision is that they never required that community to identify itself as Métis. It just had to not be Indian. Anyone indigenous who the government doesn't recognize as Indian is now Métis. And that's really problematic for me because it's kind of taking away their ability to think complexly about the histories through which they exist and possibly continue to exist today. And it gets even worse as you get into New Brunswick and Cape Breton and those areas as well. So yeah, I'm not a historian. I can absolutely see a conceptual argument made for why they would be Métis, and I think the Pauli decision would have been a much stronger decision had it talked about the peoplehood that was involved how that community was involved in kind of the evolving peoplehood of the Métis people in that era, because there are absolutely definitely connections between them. They're just not the connections that the court made, and they're not even particularly the connections that the Pauli's legal team made. Which, by the way, is not a dig at the Pauli's legal team. There's only certain arguments you can put forward with any hope of success, so you inch stuff along, hoping that further cases will allow you to open it up. Does that answer your question?
Yeah, but I was wondering in terms of that sphere of influence, is that in the book you would talk about kinship ties, but also...
You actually read the book?
Pardon me?
You read the book?
Of course! Thanks, I got the hardcover. My painting on the cover.
I know! That's you?
Otherwise, I don't know, Chris. But when I was getting to that point, it seemed like you were widening that sphere of influence and possibility. But I wondered if those extended and the aspirations of nationalism you seem to require.
Interestingly, they did have the aspirations of nationalism linked to Red River. If you look at after 1816, after the Battle of Seven Oaks, people take off for Sault Ste. Marie after that, and they refuse to arrest them when they actually get there. So the links are actually there. I vacillate in the book because I'm not a historian, so I didn't go into. None of you know me, or very few of you know me, but I don't read handwriting that's historical. I'm a historian as much as when people start typing, that's when I can really get into it. But I'm not really there's other people for that who are much better at that than I am. But for me, I'm really interested in the ways in which that emergent nationalism in the core and that growing bourgeoisie overlaps over the pre-existing kinship systems and how those different ontologies fit together, but also what are the tensions between them. And I don't have an answer to that yet, but hopefully other people will take up the book and critique it and extend it.
I have a question for Rob. First of all, I really enjoyed your book.
Oh, thank you.
That was very good. And this whole question of how people interact with each other right now, they treat each other and that type of thing, that there's spiritual dimensions to that, and there's the other story, the Osaka stories and that type of thing. But working with elders, I'm starting to understand that larger law really involves relationships with all kinds of things, like the natural world and the spiritual world, and like sort of like yourself, that type of thing. And I'm just wondering, when you were working with your elders, did you sort of hear very much about that type of thing?
The way it was explained to me is that these laws were guided human interaction with everything. It was everything. So it was more than just other humans. It was, the interaction with spirits, with the earth. So definitely it was encompassing all relations. And so someone even said, this, when we talk about all my relations, this is what we mean. We just don't mean your cousin, but we mean all your relations. Yes. And thanks, and appreciate that.
Yeah, David didn't say that. That's okay.
I'm kind of patient, so I'll give it another moment in case someone has questions.
Chris, I was going to ask you, obviously, you weren't sitting around waiting on the Daniels decision, but the point is what's your sense of what Daniels does to...
The Harry Daniels,
yeah.
I think it's a terrible decision. I think it's a good decision. I think it's terribly argued, and it reproduces this racialization that I was talking about. The court basically argues that Métis and non-status Indians were considered Indians under Section 9124, but there was the court could have just as easily argued that the term Indian today means the same, or that the term Indian then means the same as the term Aboriginal does today. So they could have made an argument that allowed for a nationalist understanding or a nationhood-based understanding, but instead they just went with the same old kind of. And I don't think it's going to make a huge amount of difference to how everyone's so excited about the Métis or Indians under 9124, but various court decisions have already argued that Métis aren't Indians under subsequent forms of legislation for hunting and fishing rights and those kinds of things. So to me, this is not the huge kind of sea change court case that everyone's making it out to be. And plus, I should say, for anyone who is Métis in the room, and even for other people, I find it really scary that we imbue the courts with as much legitimacy as we do for thinking and talking and writing about our identities. Like the Pauli decision, fantastic, they got it partly right, the courts got it partly right for once, but I'm no more or less Métis simply because I get recognized in a particular court case. But we put so much of our emotional and we invest ourselves so much in juridical kinds of logics, and it's really dangerous. I mean, we should be looking to family. We should be looking to things outside of at least the formal confines of the courts to be having these types of conversations, political conversations, cultural conversations, those kinds of things. Mm-hmm. That's just me, though. Mm-hmm.
Any other questions or comments, folks? Well, this is just the beginning for this term, and I want to thank both of you for your generosity today in coming to the University of Regina and sharing your insights and your wisdom with all of us, not only in the texts that you've created, but also in the stories that you've shared with us today. So thank you again for joining us for this inaugural event for the forum. Thank you.
Thank you.